Good afternoon, everybody. Welcome and thank you for joining us for today's presentation. My name is Matthew Curtin and I am a member of the Labor and Employment Group here at Merthyr Kalina. Today I'll be talking to you about handling the overlap of employee leave laws. First, I'm going to take a moment to go over a couple of housekeeping items. All callers are currently in listen-only mode. If you have questions during the presentation, you can write them in the questions box of your webinar toolbar, and we will answer them at the end of the presentation if there is time. This webinar is being recorded. All of today's participants will receive an email following today's presentation with the PowerPoint slides, a link to the webinar recording, and an attendance certificate. So let's get started. First, we'll talk about the agenda. We're going to initially discuss the purposes of the various laws, the general overview of major laws such as the ADA, the FMLA, and workers' comp laws, the importance of recognizing the overlap of such laws, and then at the end I'm going to wrap up with some updates on some new interpretations of the law, newer state laws that have come into effect over the past couple of years, and an update on pending legislation here in Connecticut. So what we're talking about today is really considered the Bermuda Triangle of leave laws, and that's the Americans with Disabilities Act, the ADA, the Family and Medical Leave Act, the FMLA, and corresponding state versions of the FMLA, and state workers' compensation laws. See here, we got this picture of a bunch of boats going towards the whirlpool of the Bermuda Triangle, and I'm sure that some of you HR professionals and supervisors out there have certainly felt that way when you're dealing with employees who come to you with medical impairment issues, work-related injuries or illnesses, and leave requests. It can be a very confusing and difficult topic to tackle, and even the most seasoned HR professionals and legal professionals struggle with it because the law is constantly evolving. New laws are popping up left and right throughout the states, and new interpretations of laws on the state and federal level continue to evolve the various laws. So it's something that you need to stay abreast of as an HR professional or even a supervisor. Otherwise, you're going to get sucked into that whirlpool. And consider a situation where you have an employee that is hurt on a factory floor. Say that your workers' comp insurance carrier denies coverage, maybe because the injury wasn't reported on time. The same employee has already used up their FMLA or is close to using up FMLA time, assuming that employee is eligible for FMLA leave. Same employee brings you a doctor's note restricting that employee from, say, lifting anything over 20 pounds, and that's part of the employee's essential job functions. The employee wants to return to work in some capacity, but you really are confused about how to get that employee back to work because the essential functions of the job are restricted, and you might not have some other temporary light duty readily available. At the same time, you might have a supervisor for that employee barking at you that that supervisor needs a replacement immediately, and you can't get the supervisor to stop bothering you, in addition to the employee requesting some sort of return to work. Obviously, a situation like that is going to implicate state workers' comp laws, the FMLA, and the Americans with Disabilities Act, and corresponding state versions of the FMLA and the ADA. And it's a very difficult situation to untangle. It's not easy or intuitive. It's something that you need to, from time to time, consult with your legal counsel. And we're going to talk now about some of the basics concerning the various laws, and then we're going to go into how the overlap works and try to work out some of the issues. As a warning, we're going to talk in generalizations throughout this hour presentation because Candidly, this could be a day-long presentation given all of the different state laws that touch upon unpaid and paid leave, the ADA, the corresponding state laws that protect individuals with medical impairments, and the different iterations of state workers' comp laws. So just for the sake of time and as a general overview, we're going to discuss a lot of this in generalizations, but I warn you, you have to be aware of the jurisdiction in which you're operating when dealing with these types of laws, because Connecticut's not the same as Massachusetts, Massachusetts isn't the same as New York, and New York isn't the same as Rhode Island. There's different considerations at play in all of those states, and generally when a state law provides broader protections than are available on the federal level, you need to default to the broader protections under state law. So an awareness of where you're dealing with a particular issue is key, because you might not have the same latitude, or you might have greater latitude depending on the jurisdiction in which the issue arises. So the purpose of leave laws, in a very general sense, the ADA, corresponding state protections for individuals with medical impairments, enacted to make the workplace more accessible for employees, prohibits discrimination against applicants and employees who are qualified individuals with a disability, have a record of such a disability, or are regarded or perceived as disabled. And that last part there is important, because a lot of people don't understand that an individual can have protection under the ADA or some corresponding state laws, even if they don't have a medical impairment or fit within the definition of disability under the ADA, so long as the employer perceives or regards the individual as having a disability and then discriminates or retaliates against the person for having that perceived disability. So it's important to understand that if you, for example, interview an applicant and you perceive that person to have some sort of disability or medical impairment because of maybe a limp or something else that would convey to you that there might be some sort of medical problem with the individual. Even if that person doesn't fall within the definition of disability under the ADA because of an actual medical impairment, they might fall under the definition of disability because you perceive them as having such an impairment, and then you take some sort of adverse employment action, such as not hiring that individual because you perceive that person as having a disability. So let's talk about the FMLA. The FMLA and its different iterations under state law generally allows employees the ability to balance work obligations against family obligations by setting minimum leave standards for eligible employees. Later in the presentation, we're going to get into some of the details about the different eligibility standards. Frankly, it's starting to get all over the place, and there's proposals in Connecticut to pretty greatly amend eligibility standards for the Connecticut Family and Medical Leave Act. So again, it's key to be aware of in which jurisdiction you're operating, so that you have an idea of and you can identify if an employee is eligible for FMLA protections, whether it be unpaid or paid in some jurisdictions. And now the purpose of workers' compensation laws. The purpose of workers' compensation laws basically is to help employees offset costs for medical care and lost wages due to work-related injuries or illness. Workers' compensation laws provide some modicum of job protection, and generally, in most states, prohibit retaliation against employees for exercise of rights afforded under states' workers' compensation acts. Now, the interplay of these various laws. It's important for HR and supervisory employees to have a basic understanding of the laws at issue, how the laws may overlap. Otherwise, an employer may get sucked into the Bermuda Triangle of these leave laws. And again, I used to, for a long time, I've called it the Bermuda Triangle of leave laws because generally it was these three main laws. But as we've seen over the past couple of years, especially in the Northeast and New England and New York State, there's these various state laws that are popping up that are significantly altering the landscape for paid leave, unpaid leave for employees, and it's starting to become much more than this three-pronged situation. There's just a whole bevy of leave laws that employers must take into consideration, or else they're going to get tripped up and subject to various fines, subject to lawsuits, and this exposure can be significant. Employees have private rights of action under many of these laws, which can lead to significant compensatory damages awards, job reinstatement, punitive damages awards to punish and to deter employers from violating various leave laws. So it's important to minimize the exposure and the risk for an employer to make sure that HR professionals and supervisory professionals are properly trained on the leave laws that might be in play in their various jurisdictions, and that supervisors understand where to report when they need to consider the interplay of these various laws, where they need to go to talk to HR, and HR needs to be properly trained on how to handle these situations. So now let's talk about just kind of a general overview of the three main laws that we're talking about: Americans with Disabilities Act, the FMLA and its state corollaries, and finally, state workers' comp laws. And again, we're not going to talk about state workers' comp laws in very specific detail because every state has its own workers' compensation act that applies to generally, essentially all employees, and there are substantive differences between workers' comp act laws from state to state. I'm going to talk about some Connecticut-specific stuff, but I'm not going to get too much into the weeds of other states or state-specific workers' comp laws. We're going to speak about it in some generalities just for the purposes of this exercise. So, the ADA protects a qualified individual with a disability from employment discrimination, and that sentence is loaded with legal terms of art. Qualified individual is a term of art, disability is a term of art, discrimination is a term of art. So let's talk about those. A person with a disability may include a person with a physical or mental impairment, substantially limits that person in some major life activities such as working, walking, eating. Person with a record of such a so the next definition could include a person with a record of such a physical or mental impairment. And finally, what we already talked about, which is a person who is regarded as or perceived as having such an impairment. What's not a disability under the ADA? Well, that could be a whole presentation on itself as well, and there's a lot of dispute over what constitutes a disability and what doesn't constitute a disability, but I'll give you a few bullet points here just for frame of reference. Not a disability under the ADA, an impairment that only affects a person's ability to perform a single job. Generally, pregnancy by itself is not an impairment, and when I used to give this presentation before Connecticut amended its Connecticut Fair Employment Practices Act, I think that was much more of an affirmative statement, but I think that now under Connecticut and other various state laws, as pregnancy discrimination and protections are enhanced and broadened, I want to couch that by saying that this statement may not be accurate under various state laws because as time goes by, broader protections for pregnant employees are being put into place, and pregnancy needs to be assessed very carefully when making employment determinations. Usually, the language that is used to refer to pregnancy discrimination protections is an employee who has a pregnancy-related disability or impairment. But I'd urge caution if taking an aggressive stance on that, given the way that the law is evolving, because the laws are becoming much more protective of pregnant employees, and for legal reasons and for perception reasons and for culture reasons, you may want to consider erring on the side of doing more than the minimum for pregnant employees. Being overweight, probably not a disability under the ADA, although you got to couch that. Severe obesity may qualify in some situations, so you have to make sure that you understand the context of the situation. Normal deviations in common physical traits, for example, height, weight, or strength, generally will not constitute a disability under the ADA, but again, context matters and you need to assess the situation. So what is a qualified person with a disability? A qualified person with a disability is a person who, with or without a reasonable accommodation, can perform the essential functions of the job the person holds or seeks or is applying for. So you have to take into account if somebody completely without the ability to perform the essential functions of the job, even if you are able to try and give them a reasonable accommodation. And if so, then the person is not going to be a qualified disabled individual under the ADA, and the person might not be able to avail themselves of the protections of the ADA or the corresponding state laws. Again, though, this is a very fact-specific analysis, and there is no one-size-fits-all solution. So what is a reasonable accommodation under the ADA? Reasonable accommodation can take the form of many different things. It could be job restructuring, it could be a temporary reassignment, it could be a leave of absence, it could be ergonomic workstations. There's not an exhaustive list of what is a reasonable accommodation. Again, it's a fact-specific, case-by-case determination. However, it's not a reasonable accommodation if the suggested or proposed accommodation will provide an undue hardship on the employer, or if the employee poses a direct threat to the health and safety of other employees that cannot be reduced or eliminated by reasonable accommodation. Now, what would be an undue hardship has been the subject of very much litigation over the years. So, it's a fact-specific, case-by-case determination, and I caution employers not to rush to judgment by saying that a de minimis hardship would be undue. A lot of employers are looking to try to figure out what the parameters of undue hardship might be. Again, I urge you err on the side of caution. A reasonable accommodation is working with the employee to see if there's something that you can do that will fit within the parameters of your business to try and allow the employee to work, to perform the essential functions of the job. Again, it is a remedial statute. It provides protections for employees. So employers that are very aggressive with their ADA determinations run the risk of higher exposure to ADA lawsuits. So I just talked about what an accommodation might be, and again, it could include modified or part-time work schedules. It could include light duty, special equipment, reassignment. All of these could be reasonable accommodations under the ADA, depending on the context of the employee's impairment and the needs of the employer. You know, one thing that it's often commonly understood is I find that employees often think that a reasonable accommodation is what the employee says, what the employee requests. The employee doesn't get to make the final call on what a reasonable accommodation is. If the employer offers a reasonable accommodation to an employee and the employee says, no, I want another type of accommodation, then the employee is not engaging in what we call the interactive process. The employee if offered a reasonable accommodation to allow that individual to perform the essential functions of the job, has to accept that reasonable accommodation. They can't demand a specific type of accommodation if the employer is offering what would be a reasonable accommodation. So I find that it's often a point of litigation, and it's often a point of contention when dealing with employees in real time. The employees come to the employer and say, this is exactly what I want, and I don't want anything else. The employer determines maybe the employee is asking for some sort of ergonomic desk or some sort of special equipment that is super costly, and the employer identifies some other type of equipment that is less costly, just as effective, and provides a reasonable accommodation. The employee sometimes says, no, I want exactly what I'm requesting because I read about it online or my doctor suggested it. The employee doesn't have the right to do that. The employer is able to identify a less costly, reasonable accommodation or something that's not as much of a hardship on the employer, then the employer is acting within its rights under the ADA. What is the interactive process? The interactive process is basically a dialogue between the employee and the employer. Open communications. You have to have discussions about what might be a reasonable accommodation. Once the employee has requested an accommodation or told the employer about an alleged disability, the employer must engage in the interactive process to determine whether there is some sort of reasonable accommodation to be had or not. The interactive process often ends up in a determination that you're at impasse and there is no reasonable accommodation to be had, and that the individual cannot perform the essential functions of the job with or without a reasonable accommodation. And that's perfectly fine as long as you engage in that interactive process with the employee to determine whether there's something that you can do as an employer to get the employee to perform the essential functions of the job, or to get them back to work after maybe a short leave of absence. The employer must communicate with the employee to determine whether it can help the qualified employee with a disability perform the essential functions of the employee's job. But remember, it's important to remember that the employee must communicate with the employer as well. It's often the case that employees become disgruntled, there's consternation, and the relationship can devolve significantly throughout the interactive process because the employee doesn't feel like it's getting exactly what it wants, although the employer is offering a reasonable accommodation. And again, it's not a one-way street. The employee has to communicate and work with the employer. The employee might not get everything that he or she wants out of the interactive process, but so long as the employer is offering a reasonable accommodation, then the employer is doing exactly what it needs to do under the ADA. What can the interactive process entail? Analyze the job functions. Talk to the employee about his or her limitations and determine what can be done to overcome those limitations with a reasonable accommodation, if anything. Assess options for accommodations and work with the employee to determine whether any option is feasible. Those are just some of the ideas that you can encompass the interactive process. Again, though, it can take the shape of many different things. I like to look at it as open and honest communications. The employer and the employee must work together in good faith. Each party must share information, and if the employee is not cooperating, this is important. Make sure to document those communications. If it's oral communications, as an HR representative or a supervisor, if you're having these communications with an employee and the employee is not operating with you in good faith, or you think that the employee is being difficult or unreasonable, make sure to contemporaneously record your perception of those communications, because often this devolves into an administrative agency charge of discrimination or failure to reasonably accommodate, or a lawsuit in state or federal court. And if you have those contemporaneous recordings of the conversations that you had with the employee, it will be much more defensible, so that you can say, on X date, I had this conversation with the employee, I offered this accommodation, We deemed it to be reasonable given the facts and circumstances. The employee said no, that they wanted a 2-year leave of absence because they thought that they wouldn't be able to perform as well and their doctor said that they should really take time off from work indefinitely, or the employee said, no, I want the $5,000 standing desk as opposed to the $1,000 standing desk, and I'm not going to budge on my position. Make sure you document those things to the file so it doesn't become an outright he said, she said credibility determination if it does end up going into litigation. Light duty work is a reasonable accommodation. Sometimes it is a reasonable accommodation. What is light duty work? It's often understood to be a job that is less strenuous, either physically or mentally, than the job the employee regularly performs. It can be a reasonable accommodation under the ADA, and sometimes under the ADA, an employer may have a duty to create light duty work. I often see that no light duty policies. The EEOC takes the position that those are unlawful under the ADA. There's dispute in the courts about that, so generally I caution against that. If it's unreasonable to create light duty work, or there's an undue hardship, obviously that's not a reasonable accommodation. But if there is an open position, or there's work that's available for a qualified disabled individual to temporarily perform until he or she can perform the essential functions of their job duty without restriction again, it could be a reasonable accommodation. Might not be, but again, it's a facts and circumstances test, and you can't just absolutely rule it out. I will note that where an employee suffers a work-related injury but is not a qualified disabled person under the Connecticut Workers' Comp Act, an employer only has to transfer employee to light duty work if such work is available, where under the ADA, if you're a qualified disabled person, an employer may have to create such work. And again, there is that overlap where sometimes an individual who sustains a work-related injury might not qualify as a qualified disabled individual under the ADA or the Connecticut Fair Employment Practices Act, because the impairment is temporary and transient in nature. But if it's a chronic impairment, there may be overlap, and the ADA might apply, and the employer might have to do more than it is required than under the State Workers' Compensation Act. So we're going to move on to a little bit about the State Workers' Comp Act. I'm going to use Connecticut just as an example because that's where I practice mainly for employment law. I wanted to talk a little bit about workers' comp retaliation and discrimination. In Connecticut, we have a statute directly on point that prohibits employers from retaliating or discriminating against employees due to an employee's exercise of their rights under the Connecticut Workers' Compensation Act. The burden of proof is on an employee to prove retaliation or discrimination. The employee must show an exercise of rights under the Workers' Comp Act, and it might not be that the employee filed a claim with the state commission. It could just be that the employee put the employer on notice of a work-related injury, tried to file a first report of occupational injury with the employer, and the employer did not process that. So that could be exercising your rights, or it could just be as simple as an employee telling HR, I sustained a work-related injury, HR doing nothing about it, and then terminating the employee because of that work-related injury. Not a common situation, but that could be a situation where there could be liability. So it doesn't have to be the case that the employee files a claim with the Compensation Commission. It could just be a discussion in the workplace that the employee attempts to exercise their rights. 31290A, which is the workers' comp retaliation statute in Connecticut, doesn't guarantee an injured worker his job when the employee is well enough to resume work if the employee is unable to perform the essential functions of the job. So it's not. It provides a modicum of job protection, but it's not a per se job protection statute. An employer may replace an injured worker if necessary. However, When the injured employee is ready to resume work, the employee must be given every consideration if there is a job available for which the employee is qualified. Now, I'll couch that in saying if the employee is considered a qualified disabled individual under the ADA, that bullet point might not apply because you might have to go above and beyond what's required under the Connecticut Workers' Comp Act and consider what kind of reasonable accommodations that you could make for the employee. And a reasonable accommodation could be a temporary leave of absence, 2 or 3 months. Sometimes it's 6 months under the case law. It all depends on the facts and circumstances of the case. And when you're looking at workers' comp retaliation, you want to watch out for cases where an employee files a claim and is subsequently disabled. Like we've been talking about, the ADA may also come into play. This case is an older case, but I find that it's a good example of the interplay of workers' comp and the ADA, and this is Aristoy versus Merrill Machine Company. Merrill Machine Company, it's a sewing machine company, or was. Aristoy was a piece worker for Merrill Machine Company. She incurred carpal tunnel syndrome in the course of her job. The employer provided her with light duty for a period of time. Eventually, Aristoy's doctor diagnosed her as totally disabled, told her that she had to stop working. Eventually, a period of time after that, she was released to work, but with significant restrictions. Merrill Machine Company eventually terminated the Aristoy's employment when she tried to return to work with her restrictions because all the jobs within her department aggravated her conditions. There were no long-term suitable jobs that were open or available for her given her conditions, and the Connecticut Appellate Court determined that she was not qualified for any of Merrill's jobs. So under the Workers' Comp Act, there was no workers' comp retaliation or discrimination because she simply couldn't perform the jobs that were available, and there was really no accommodation for her because she couldn't operate the sewing machines. So there was a consideration. In that case, if the ADA came into play, I think it would be fair to say that she would not be a qualified disabled individual under the ADA because she wasn't able to perform the essential functions of any jobs in her department with or without a reasonable accommodation. And there was certainly no workers' comp retaliation because she simply wasn't qualified for her job anymore given her significant restrictions due to her carpal tunnel syndrome. Another landmark case in Connecticut concerning workers' comp retaliation and discrimination is Chiea versus Pepperidge Farms, another Connecticut appellate court case. It's a little dated now, but it still remains very good law in Connecticut as far as workers' comp discrimination is concerned. In Chiea, the employer maintained a per se attendance rule. So that if any employee was out of work for more than 12 months at a time, the employee was automatically terminated. Here in Chiea, the employee suffered a work-related injury. The employee was out of work due to those work-related injuries for more than a year. The employer terminated the employee pursuant to the neutral per se attendance rule. The Connecticut appellate court found that policy was valid so long as it was uniformly applied to all employees, regardless of whether the absence was due to work-related injuries or not work-related injuries. You have to be careful, though, because the EEOC, in construing ADA issues, has taken a very dim view of the per se attendance rules. There are ways, a lot of employers still maintain facially neutral per se attendance rules. 12 months, I think, is generally a reasonable time frame for a per se attendance rules. I've seen case law with per se attendance rules that have shorter periods of time and the employer prevails, but I've also seen the converse where the employer does not prevail. It's different from that case law is different from jurisdiction to jurisdiction as far as disability protection laws go. So while in Connecticut this is still good law as it pertains to the Workers' Comp Retaliation Act, you still have to be careful when assessing these long-term absences due to disability in the context of the ADA, because the EEOC can very well take the position that long-term absences can be a reasonable accommodation, although I think that the case law is pretty clear at this point that indefinite leaves of absence are not reasonable accommodations under the ADA or corresponding state disability laws. And also the type of absence, I'm sure a lot of the HR professionals in the audience see, where somebody keeps saying, I'm going to return. 3 months later, they come back and say, still can't return. 3 months later, they come back and say, still can't return. This kind of repeat, indefinite leaves of absence, those are probably the hardest ones to deal with, because you really do have to get your paperwork in order to make it defensible if they claim disability discrimination or retaliation in the future, because generally maybe a 1 to 3 month temporary leave of absence might be a reasonable accommodation given the facts and circumstances. But say that it keeps happening over and over and you get a year out and the employee still keeps getting certifications from the doctor saying, I'm going to reassess in 3 months. And at that point, I do think it's likely the employee will be able to return to work without restrictions, but it just keeps happening over and over. If there's no reasonable expectation that the employee is going to return at the end of that 3 months, sometimes it is okay to terminate, but I urge a lot of caution with those situations, because those seem to be very fertile ground for lawsuits. We see a lot of lawsuits over that, where the employee gets a doctor saying over and over, yeah, they're going to return, but they just never do. So I urge caution with that one, and I would talk to legal counsel before making any termination decisions on that particular situation. So we just kind of covered this slide. Probably should have went to that slide, but per se termination policy may be lawful under 298. Employer, you got to take into account the ADA. And speaking of indefinite leave, indefinite leave by itself is generally not going to be reasonable accommodation. But what's indefinite is sometimes subjective, and it can be, in the eyes of HR, you might think that somebody's requesting indefinite leave. The employee or the doctor that's certifying the employee might not see it as indefinite leave. So again, you have to be careful with these indefinite leave situations, and I would talk to your internal or your outside counsel about it if you have one of these situations and you think there's risk. So finally, turning to the FMLA, and in the interest of time, I'm going to go through this pretty quickly. I don't want to talk too much about coverage, but you'll get the slides after this. And there's different eligibility standards for coverage under the federal and state FMLA, and not only Connecticut state FMLA, but other states' mini FMLAs, if you will. There are a number of different criteria for what might allow an eligible employee to take FMLA protected job leave, and some of those are listed here. Under the state, the state differs slightly from the federal FMLA. So from state to state, you have to make sure that you understand what types of situations eligible employees may take FMLA protected job leave. And if there's greater protections under the state law, you have to defer to the state law. Generally, FMLA provides for notice requirements 30 days in advance when foreseeable, as soon as practical when not foreseeable. That can differ under state law. Generally, under the FMLA, employers can require employees use paid leave time before using unpaid leave. FMLA can generally run concurrently with workers' comp leave, disability leave, and sick leave. So if an employee has that accrued paid time off, you want to exhaust that with the FMLA. There are intermittent or reduced schedule leave available in certain circumstances, and there is health insurance maintenance under the federal FMLA. So let's start talking about the interplay a little more in detail. Interaction of the ADA and FMLA. Leave provisions of the FMLA are wholly distinct from ADA reasonable accommodation requirements, and they need to be conceptually framed differently. You can't conflate the two, and to the extent that there are differing requirements under the FMLA and the ADA, you have to look at them separately and generally defer to the broader protections. ADA can allow for indeterminate amount of leave, although again, that's a little different than indefinite. If somebody says, I will never be able to project one, I'll be able to return, but I might be able to someday, generally giving that person indefinite leave of absence isn't going to be considered a reasonable accommodation. But again, those are some of the most difficult situations when looking at the interplay of ADA and FMLA. An employee is entitled to FMLA leave. An employer can't require the employee take a job with a reasonable accommodation. So if your employee is eligible for the FMLA leave and can take a leave for a serious health condition, you can't force them to stay in that job by saying we have some other type of reasonable accommodation job that will allow you to continue. You have to let them go out on the FMLA leave. Note that where the ADA and the FMLA overlap, the employee is always entitled to take advantage of whichever law provides greater benefits and rights. For example, FMLA leave can also be a reasonable accommodation, so an employee is entitled to the same job on return as required by the ADA, as opposed to an equivalent job as required under the FMLA, because the ADA provides greater rights upon return in that specific situation. If an employer requires a fitness for duty certification upon return from FMLA leave and the employee is a qualified disabled individual under the ADA, the certification must be job-related and consistent with business necessity. So for medical documentation, let's just kind of go through we'll compare these three types of leave laws side by side. Medical documentation. FMLA, the medical certification should demonstrate the need for leave but not exceed what is requested by the DOL's or the corresponding state DOL's medical certification form. Workers' compensation. Medical information should detail the employee's on-the-job injury, but it shouldn't go beyond that. Under the ADA, medical documentation should be limited to determining an applicant's or employee's ability to perform the job and whether an accommodation is needed and would be effective and would not pose an undue hardship or pose a substantial threat of harm to other employees. Can you request a second medical opinion? Under the FMLA, yes, by a doctor not regularly employed by the employer at the employer's expense. You can also require a third certification by a doctor, a tiebreaker, approved by both the doctor would have to be approved by both the employer and the employee, and that third tiebreaker doctor would be a final decision. Under the ADA, no real statutory provision, so you have to assess the facts and circumstances. Under the workers' comp, yes, generally. I mean, it depends on I guess it would depend on the state that you're in, and I haven't analyzed all the state workers' comp laws, but yes, generally to determine the nature of the injury and resulting incapacity. Length of leave entitlement. FMLA, generally 12 weeks per year. Under the Connecticut FMLA, however, it's different, 16 weeks every 2 years under the Connecticut FMLA. Under the ADA, sometimes a lengthy leave is a reasonable accommodation, but I will say an indefinite leave is not reasonable. I think that's a defensible position to take, and I think that the majority of courts are now agreeing with that. Workers' comp, it depends on the nature of the injury. Generally, an employer is not required to indefinitely keep the employee if he or she's not is unable to perform the job. If light duty work is unavailable and there is a neutral absence control policy. What about intermittent leave? or a reduced schedule. Under the ADA, yeah, that could be a reasonable accommodation. A modified work schedule may be necessary. Regular attendance is generally an essential job function, but not always. And see, for example, there was a recent case out in the Sixth Circuit where an employer maintained a written job description stating that regular attendance, physical presence and regular attendance was an essential job function. The employee demonstrated to the court that she could perform all job functions from home on her own schedule, and therefore the job description was inaccurate, and I think in that case it was considered outdated. So the employer did not get summary judgment in that case, and it was remanded for further determination. But that's just an example of the fact that regular attendance might not always be an essential job function. What about intermittent leave or reduced schedule leave under the FMLA? Well, under the FMLA, yes. I think it's pretty explicit in the FMLA that intermittent leave is available when medically necessary for serious health condition or for some other types of leave under the FMLA. You can require a temporary transfer to an alternate position. You can require the employee to submit documentation concerning duration of planned treatment and need. But generally, intermittent leave is available under the FMLA if a doctor will certify such. And under workers' comp, at least in Connecticut, you have to provide full-time suitable light-duty work if available and consistent with the injury or illness that the employee is suffering, but you're not required to create such a position if it does not exist. Now, what about light-duty work requirements? Under the ADA, maybe. It's a facts and circumstances situation. If a position is available and there's no undue hardship, transfer to temporary light-duty work could be a reasonable accommodation. If there's work that's not getting done, but there's no light-duty position that is actually in existence, it could be a reasonable accommodation to assign that work to the qualified disabled individual on a short-term basis to keep them employed and working. But again, you need to analyze the facts and the situations because it could be an undue hardship to the employer, or in some situations it could provide or pose the risk of a substantial injury or a threat of harm to other employees. Under the FMLA, no obligation explicit, and the employer cannot force an employee into light duty in lieu of FMLA. State workers' comp laws, like we just said before on the last slide, you got to provide full-time suitable light duty work if available, but you're not required to create a position. I will say, though, at least under Connecticut law, an employee's refusal to accept light duty work could result in the denial of workers' compensation benefits. So all of those three different leave laws slightly differ as to their light duty work requirements. What about pay status while on leave? ADA could be an unpaid leave of absence could be a reasonable accommodation. FMLA, generally unpaid, although lots of these state laws now are starting to require pay for certain eligible employees. Put that aside for a second. We'll just say for now, generally FMLA is unpaid, but the employer may require the employee to exhaust accrued PTO concurrently, so long as it's pursuant to the employer's established policy. So you want to make sure that you're following your policy and that you're not treating somebody on FMLA differently than other employees. Workers' comp, paid pursuant to a statutory formula. It's not much discretion there on the employer's part, if any. The employer or the employee can require it to run concurrent with FMLA where applicable. How about benefits and seniority? Under the ADA, it depends on the employer's policies, but no statutory right to accrual of seniority or benefits. FMLA, health insurance continuation is in play. Seniority and other benefits need not accrue during leave, but must be reinstated upon return. Workers' comp, no right to accrual while on such leave. You also want to check any collective bargaining agreements that you might have in play we haven't really talked about unionized environments right now. I mean, as a baseline, all of this applies to union environments, but there might be different requirements concerning leave that the employer and the union might have bargained into play. Reinstatement rights. Under the ADA, employees should be reinstated to the job unless doing so creates an undue hardship, but the employer isn't required to eliminate essential functions of a job or to create a light-duty job upon return, an indefinite light-duty job. FMLA, you have to return the employee to the same or the equivalent job, or an equivalent job in terms of responsibilities and compensation. There's not an undue hardship exception. There is for certain key employees who are usually higher up executives, highly compensated individuals. That same key employee exception doesn't exist under the Connecticut state law, however. Employers can request fitness for duty reports upon return to work under the FMLA. Workers' comp laws, generally no reinstatement rights, but again, the retaliatory discharge laws come into play. So let's talk about prevention in the real world. We're running out of time. There's a few things I want to touch upon before we get out of here. But job descriptions, important tool to establish and, if necessary, prove objective criteria used in hiring and termination decisions. Under the ADA, it's useful to prove essential functions of the job, thus reducing likelihood of discriminatory hiring practices and outcomes. But make sure that your job descriptions are up to date. And we talked about that case from the Sixth Circuit earlier where the job description was outdated. If your job descriptions are outdated, they're useless. You got to make sure that they stay up to date and that the job descriptions are accurate. Pre-employment inquiries. The ADA allows employers to ask questions about the ability to perform job-related functions. Employers cannot make pre-employment inquiries concerning disabilities generally. It's just about whether they can perform job-related functions. After making a conditional offer and before a person starts work, an employer may subject the person to a medical exam or ask health-related questions so long as all candidates are treated uniformly. Personnel files. It's important to keep personnel files, obviously, but that might seem obvious to everybody. Why are we talking about it? Because often it's the case. You ask an employer for an employee's employee file, and there's a whole bunch of medical records in there. The medical records should be segregated from personnel files. Under Connecticut law, it's required. So all documents prepared by a physician, psychiatrist, or psychologist, even if used to make an employment-related decision, should be segregated from a employee's regular personnel file. Just a quick update on where we are with some updates on the FMLA. The Federal Department of Labor recently issued some opinion letters, which are generally non-binding but provide useful guidance. I think that this point is we should make during this presentation. In a recent opinion letter that was issued in March, the FMLA took the position that employers cannot delay the start of FMLA leave. Employers sometimes require employees to exhaust accrued paid leave prior to officially designating leave as FMLA protected. DOL now takes the position this is an FMLA violation. So look, I think the bottom line there is if an employee comes to you with a situation that requires FMLA protected leave, you can't delay the designation of the FMLA so that they exhaust all their accrued paid leave first. It has to run concurrently. The other point, and I think this is a lesser point, but another point the DOL made in these opinion letters is substitution of paid leave. An employer may not designate more than 12 weeks of leave in a year as FMLA leave. And again, this is under the federal FMLA. State leave, FMLA leave laws might be different, but I just wanted to make that clear that you can't give more generous protection under the FMLA. They get the 12 weeks, and you can't designate more than that. Again, though, the ADA, you might have different considerations. Under workers' comp laws, you might have different considerations. State paid leave laws, there are a number of them, especially we'll focus on the Northeast for now. Massachusetts paid family and medical leave, that's going into effect in 2020. Some obligations start as soon as 2019. There are proposed implementing regulations out there that I think are going to be finalized soon. If you do business in Massachusetts and you're concerned about whether you might be subject to that Massachusetts Paid Family and Medical Leave Act, consult with counsel and find out if you're subject to that law and what that's going to entail for your company. If you are subject to it, you're going to have to get policies in place. You're going to have to disseminate notices to employees. There is going to be some work to ramp up on that. New York State Paid Family Leave Act, January 1st, 2019. Rhode Island Paid Family Leave, already in effect. New Jersey, already in effect. All these are funded through employee-paid payroll taxes. So while employees might be getting a benefit, they might be surprised to learn that they are also taking home less money because it is all being funded through payroll taxes. I don't want to go too much into detail in the Massachusetts Paid Family and Medical Leave. I did put some information in there in bullet points if you want to refer to that later. I'll just note that on July 1st, 2019, covered employers must post a notice informing employees of their rights under the law. One other thing that I wanted to note, because this is a fluid situation, but I think it's very important for Connecticut employers, is that there is proposed legislation pending in Connecticut right now before the Connecticut General Assembly, proposing to amend the current Connecticut Family and Medical Leave Act, create a Paid Family and Medical Leave Act. It's generally accepted that some form of law will pass implementing paid family and medical leave. It's not definite yet as to what that will look like. The bill continues to be revised as it winds its way through the Connecticut General Assembly, but as you can see, it's that the Senate bill is designated as Connecticut Senate Bill number 1, which is generally indicative of the fact that it is the Senate's #1 priority. So I would expect, and I think it's generally well accepted, that this will pass in some form in 2019. When it will be effective, I don't know because it's still subject to revision. In its current form, these bills would create the Family and Medical Leave Insurance Program to provide wage replacement benefits to certain employees taking leave for reasons allowed under the Connecticut FMLA. It will be up to 12 weeks of benefits over a 12-month period in an amount equal to 100% of the employee's weekly earnings, up to a max of $1,000 weekly. Significantly, the proposed legislation would make substantial changes to state FMLA eligibility rules. I don't want to get into what that would look like yet because I think it's still subject to revision, and until we see the final version of the Public Act, it's nice to know it's coming and to start preparing, but until we have a final version of the legislation, it doesn't help too much because these things tend to be revised as they wind their way through. I will say in its current format, the new law would apply to most employers with at least one employee. So I feel like Homer putting my head in the hand because it's going to be a nightmare for everybody trying to get their heads around this new paid family leave legislation. It's going to take a lot of work to ramp up on how to implement that in the workplace in Connecticut and to figure out how it amends existing regulations. So I didn't leave much time for questions here. It is 12:59. I will say we've got 1 minute. Let me see if I can get anything in under 1 minute. No, can't. Sorry. These are pretty detailed questions. I'll follow up with the the questions that I have there. I'll do my best to follow up with you within a reasonable amount of time. I'm sorry I didn't leave a lot of time for questions, but this is a very dense subject, and there was a lot I wanted to cover, and there's a lot I didn't even get to cover. So I hope that this was useful for HR professionals, supervisors, Please follow up with me if you have questions and you want to talk about it. I'm always happy to talk. My information's on the slides that will be distributed. Thanks for attending today. I greatly appreciate you giving me an hour of your day on a Friday, and I hope that you attend our future webinars. Thank you.